Let us start solving the questions of Indian Evidence Act. First of all, we read the quotation. आज मुश्किल है पर कल बेहतर होगा, बस उम्मीद मत छोड़ना. It means hope is the life. Okay, next question, number first. Question first. Which of the following facts need not to be proved? Which of the following facts need not to be proved? There are four options, and here it is mentioned that one of them explain about the facts that need not to be proved. First of all, the facts which are covered under the doctrine of res justi, it requires to be proved. The second one, the facts which are written in the police statement, it is also required to be proved. But the facts which are admitted under section 58 of Indian Evidence Act, under section 58 of Indian Evidence Act, admitted fact need not to be proved. So the correct answer of the question is C. Next, facts which need not be proved by the parties. If the parties admitted any facts, those admitted facts shall not be required to be proved. So option A, facts which have been admitted by the parties at or before the hearing. If any fact is admitted by the parties, then burden of proof of that fact shall not lie. Burden of proof always lie on those facts for proving that fact that is not admitted by the parties. If the parties admitted any fact, those facts shall not be required to be proved. So here parties admitted the facts, so it is not required to be proved. So the correct answer of the question is A. It is also relating to section 58 of Indian Evidence Act. Okay, if any fact is admitted by the parties, that fact need not to be proved. So the correct answer of the question is A. Yes. Next question. A judicial admission operates as an admission, a confession, a plea of ignorance, a waiver of proof. Yes. No proof is required. If a person admitted, it means any person makes a confession before judicial magistrate, that confession need not required to be proved. It means a waiver of proof. Proof is not required. So the correct answer of the question is D, a waiver of proof. Next question. Contents of a document under section 59. Contents of a document under section 59 of the Indian Evidence Act 1872 can be proved by oral evidence. Contents of a document under section 59 of the Indian Evidence Act 1872 can be proved by oral evidence, cannot be proved by oral evidence. If section 59 says that contents of oral evidence can be proved, can be produced as an evidence to prove any fact except contents of the document. It means contents of the document cannot be proved by the oral evidence. So contents of a document under section 59, because section 59 says that content of Indian Evidence Act 72 cannot be proved by oral evidence. Yes, cannot be proved by oral evidence. Can be proved? No. Many may or may not be proved by oral evidence. It is also can only be proved by oral evidence under the orders of the court. Under the orders of the court. According to section 65. According to section 63, oral evidence is also secondary evidence. First of all, any fact if is to be proved, first of all, section 62 says that primary evidence is required. Primary evidence is required. But what is primary evidence? The primary evidence is defined in the section 62. But section 61 says that to prove any fact, first of all, primary evidences are required. Primary evidences should be produced. Any content, any fact, if is to be proved, first of all, primary evidence should be produced. What is primary evidence? Primary evidence is defined in the section 62, whereas secondary evidence defined in the section 63. What type of evidences are known as a secondary evidence? What type of evidences are known as a primary evidence? Section 62, section 63. But here it is very necessary that contents of a document under section 59 of the Indian Evidence Act cannot be proved by oral evidence. Yes, is it correct answer? If you 59 depth, you find it. So the correct answer shall be B. Next, all facts except the contents of document may be proved. All facts except contents of document may be proved by oral evidence. May be proved by oral evidence. Section 59 says that. Section 59 says that all the contents, all the facts except the contents of the document may be proved by oral evidence. It means contents of the document shall not be proved by oral evidence. Any content, if is to be proved, only and only documentary evidence is required. So the correct answer of question 5 is C, oral evidence. Okay. All facts except the term is used. What can be proved by oral evidence? Contents of a document? No. All facts? No. Contents of electronic record? All facts except the contents of documents and electronic record. Section 59 says that. So the correct answer of question 6 is D. D is the correct answer. The rule as to direct oral evidence. The rule as to direct oral evidence is contained in the Evidence Act. Under section oral, the rule as to direct oral evidence is contained in the section 60. Section 60 says that whatever oral evidences are produced, that must be direct. That must be direct. So it is mentioned in the section 60. Section 60. And so it is an exception to hearsay evidence. Hearsay evidence is no evidence. In which section? Indirectly mentioned. Section 60. The correct answer of the question is section 60. It excludes hearsay evidence as an evidence. So section 60 affirms that oral evidence must be direct. Next question. Which of the following section of the Evidence Act recognize the principle that hearsay evidence is no evidence? Hearsay evidence is no evidence. In which section it is mentioned? Section 60. Because section 60 says that oral evidence must be direct. Oral evidence must be direct. It means it exclude hearsay evidence. And so hearsay evidence is no evidence. It can be said according to section 60 of Indian Evidence Act. S. Yet says that Y told him that A killed B. This is a hearsay evidence because the evidence is not direct. Evidence is not direct, and where the evidence is not direct, it is based on heard things, seen things, and other person told. It means if a person hears about a thing, if A says B about C and B produces evidences about C, this is the hearsay evidence. And if A produce the evidence in the court, such evidence is not regarded as an hearsay evidence. It is a direct evidence. So, evidence of B, evidences produced by B shall be regarded hearsay evidence. Here, yet says that Y told him that A killed B. This is hearsay evidence because if Y produces evidences regarding to this fact, evidences produced by Y in the court shall be called hearsay evidence. Okay? Next question. A informs B. A informs B that he has heard from X that Z has committed murder of C. Z has committed murder of C. Few days ago, evidence of B, when examined as a witness in the court, would be considered as a hearsay evidence because such evidence is based on hearing information. So the correct answer of the question is B. Okay, this is the correct answer. Yes, thanking you for watching this video.